137 sub 1 paragraph D. So these are things that, are very, very important for us to know. As for the decree of forfeiture, I want to state expressly that there is no need asking that crazy question that was brought up by the person of one senior advocate of Nigeria talking about civil or criminal forfeiture. You cannot forfeit funds in a criminal case and say that that forfeiture
I think we lost
I received a call. Sorry about that. It
Go ahead.
is okay. It is insane for anybody to say that. So it was a forfeiture, whether criminal or civil. There was a case that has to deal with dishonesty, as mentioned in section 137 sub 1 paragraph D. Another thing I would like to note is that some people who will be subpoenaed in this case is the staff or Amazon cloud platform. These are the people who hosted, the live updates or live back end feed of INEC. It is very important. Now, according to the law, evidence law, for you to be able to tender some certain documents, the person who created that document needs to be present to tender the document. So if you are going to tender an analysis of a website, because they are saying that the glitch that happened was a lie, there was no glitch, or the glitch was nothing to hamper the proper upload, since there was a possibility for you to upload the legislative elections, so it shouldn't hamper the presidential elections. So persons from this Amazon cloud platform will also be subpoenaed to come out and also testify in the document. Then just one more thing, and the emphasis will be done, is that Peter Obi was able, through his petition, to really lay emphasis on Benue State and Rivers State. I don't know why they were particular about these two states. And after mentioning these two states in the petition, they added and other places where these things happened. They did their computation from everything that happened in Rivers State, and they saw that the figures which were released were actually a lie. And funny enough, Peter Obi will be relying on forensic evidences that is showing overvoting in, I will list the states, in Ekiti State, Oyo State, Ondo State, Osun State, Taraba State, Kano State, Rivers State, Borno State, Katsina State, Kwara State, Gombe State, Yobe State, and Niger State. So these are the states that were listed in that petition as containing evidences of overvoting, and INEC went ahead to actually accept results in these places. Also, they will be relying on forensic evidences, which we are showing that the results that were computed were not legitimately computed. So by one means or the other, whether there was padding or whether there was change of figures, and they listed some states also. You can see that in paragraph 72 and 73 of the document. They listed Lagos State, they listed Rivers State, they listed Taraba State, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, Plateau, and other states. So these are states where, by virtue of one thing or the other, the padded results or the illegitimately computed results for the respondents. The respondents being Tinubu, Shetima, and the APC. So this is very, very instrumental. Of course, Doja has talked about the issue of the 25% in FCT, which is their third ground for which they are using to contest the election. The petition overall is very, very wonderful. It is a good petition. In the petition, however, they did not go through, because there are processes to election petition. That is why not all lawyers do election petition. So there are processes to it. This is just where you tell the court what you are coming to the court to do, things you'll be relying in the courts, and all of it. So there was no express mention of a lot of provisions of the Constitution, of the Electoral Act, or of basically the petition will be resting on the Constitution 1999 of Nigeria, the Electoral Act as passed 2022, the regulations and guidelines for the conduct of elections as released by INEC in 2022, manuals for elections, which INEC also released for their staffs. These are statutes that they will be relying on. Some other documents include the memos that was released. If you remember, INEC started deleting some things on its Twitter handles, if you recall very well. These are some of the documents that will be tendered in court, where they expressly said that they were going to upload in real time. So these are the places I want to lay emphasis on, and I think that suffices before other questions. Thank you very much.
Thank you so much, UC Maxwell. I think Barrister Juliet has something to say. Barrister Juliet, go ahead and unmute your mic. Let's hear from you. This is getting interesting. I mean,
Okay.
I'm loving it already. So go ahead, guys.
Yeah,
Barrister Juliet.
yes. Actually, one of the things I wanted to really expand on was Section 137, which UC Maxwell has already touched on. But I thought there was going to be a point, maybe everybody just comes, give a normal narrative. But since we may actually be allowing Barrister Doja go to the next petition, which is on Atiku, I think it's just good to actually state some certain things, which for me, I already prepared to actually let people know. The reason why this petition is actually starting from the Court of Appeal is that's based on the jurisdiction of the court. I know a lot of people will be like, why not the High Court, as the other tribunals constituted by High Court judges? But first of all, we must understand that for presidential elections in Nigeria, according to Section 239 of the Constitution, matters relating to presidential election, vice presidents are actually going to be instituted in the Court of Appeal. And then actually, now we already understand that it's 21 days to actually file from the time results were announced, which was March 1st. So we can actually understand why this petition was filed with latest on the 22nd of March, which was on Wednesday, rightly like WME said. So the respondents actually have 21 days to actually reply. So from within 21 days, they have a right to reply the petition, as actually we've seen. So which we are going to be eschewing. And then most of all these laws, why a lot of us were going to be why we're talking about these laws is based on the provisions of the Electoral Act, the guidelines that's for conduct of elections, the Electoral Act and guidelines, that's guidelines for 2022, is actually going to be eschewed in the course of this conversation, because most of the issues, the facts in which was laid down by the petition, I would say PO's petition, because we are going to be talking about two petitions here. So what most of the grounds and also that of Atiku's petition is actually based on these laws. So you cannot go outside the laws, actually outside the laws which are provided to down start raising issues. And the only three grounds which you can actually seek to contest an election in Nigeria are just those three grounds which are contained in Section 134 of the Electoral Act. And that's why we see the similarity in the grounds for the petition between PO and Atiku's petition. One, you must tell us that you must establish before the court on preponderance of evidence that a person was not actually qualified to contest. Secondly, corrupt practices or non-compliance with the provision of the Act. And then the third one is that the person was not duly elected by majority of lawful votes count. So as we are going through those three major points, you'll see that there are dynamics to it. A person actually can win election based on majority, but the Constitution has actually provided the grounds for which you can actually declare a person winner, not just only by majority votes. And that's what, as we go on, you will see that it was not just based on majority votes. Both petitioners are actually going to be asking the court for. There are also going to be specific things which they'll be praying that, which they are asking that the respondents did not meet these criteria. And so, but another thing is that what I was saying from the non-compliance of the provision, there's something that the Electoral Act says, and these are the things that the petitioners must establish before the court, because the Electoral Act says that an election shall not be liable to be invalidated by the reason of non-compliance. So that means the fact that you raise non-compliance does not mean the court will just already invalidate all elections. Is that incompliance must see to be that it affects substantially the results of the election. And so whatever grounds the petition of PO, the petition of Atiku are asking the court for right now is that the non-compliance was deliberate enough, was substantial enough, was very evident to affect the results and the turn-up for the results returned, for the votes returned by each of the collation officers, the returning officers, that those non-compliances affected the results in which they actually declared. So this is actually have to be put into consideration then for the court then to decide. The fact that you raise non-compliance does not mean automatically that that election will just be declared null and void. And so those were just one of a lot of things that the petitions contained, and like Barrister Georgia has already talked about the qualifications aspect from the senatorial, the third respondent being Shetima, and then why he's not qualified, and then so talking about the second respondents being Asiwaju and all that. Those are the cases the petitioner is actually trying to estray. But the significant part about this petition is that the other petition from Atiku does not contain the issue of that's one thing, because when we started this space, there was something Mark said. He said we're going to be talking about the similarities and differences between both petitions. For Atiku, there's similarity on the grounds of non-compliance. There's non-compliance on a lot of states and all that. But when it comes to disqualification, it just stated, and that's something unique, it stated that they will actually be depending that the respondent did not meet the constitutional threshold. Now, the constitutional threshold was not actually estrayed. I'm sure they have reasons why this constitutional threshold was not estrayed. But the good thing about the petition of PO is that he estrayed the grounds upon which the court should look into the disqualification of the second and third respondents. So now highlighting the nomination, the double nomination, and the Electoral Act is very express on nomination of candidates, double nomination in Section 35 of the Electoral Act, Section 155D. All these things estrays the nomination. When a person is nominated for 2 constituency or more, that actually is from the law. They're actually going to be estraying the issue qualification or not. We already talked about Section 1, either is sentence or fine. So the unique thing about this thing is that it captures sentence or fine. But now the thing is that should there have been a conviction? Is there actually a crime? The Constitution is already expressly clear that whatsoever the crime is, when it relates to sentencing or fine by a candidate, such a person should not actually participate in an election. It's very clear, and it's now for the court to decide to what extent will it be actually saying if second respondent is qualified or not qualified. And remember, the competent court of law or tribunal in Nigeria or sentence of imprisonment or fine of any offense involving imposed on him by any court. So first of all, the court has already said, the Constitution has already said, if there is a sentence of death imposed on him by any competent court in Nigeria or tribunal in Nigeria, that's one. But it now gives a wider ambience. So if found that this is true, there was actually a sentence of imprisonment, or there's a fine actually meted to such person in any court in Nigeria. So it has a wider avenue to accommodate any court of law. So it was not necessarily be in Nigeria, as some people will actually be thinking that it must be a competent court from Nigeria that must sentence the person or must have convicted the person or must have issued a fine to a person with regards to an offense committed. And so I think that's just it. The non-compliances. One good thing about Atiku's petition that I said there is a difference between that of Atiku and that of PO is this. For Atiku, he actually
would I want to stop you here now so Barrister Georgia can touch on that, and then you can now piggyback on it afterwards. So let's allow Barrister Dodger now do justice to that, please. So thank you so much, UC Maxwell and Barrister Juliet. I'm loving this already, guys. I don't know about you guys, but I am loving this. Please share the space. Share the space. We need to be hitting about the 500 mark people here right now. Let everybody come and hear this from a layman's view. Let's understand what this petition is all about. Please, we're getting this on a platter of gold. I beg you guys, share the space, share the space, share the space. Barrister Juliet, sorry, I just want Barrister Dodger to start up with that, and then you can take it from there. Let allow him go with. Let's allow him give us a summary of the Atiku's petition. So, Barrister Dodger, go for it, sir.
Thank you very much. I don't know if Barrister Julia still has anything to say, but I'll defer to her. The summary I'm about to make of Article's petition doesn't really affect what she's saying. Or what do you think, Barrister Juliet?
Okay. My apology, Barrister Juliet. Go ahead.
For me, I just feel Barrister Doja can go ahead, because for me, I was still actually a PO's petition on the second ground. So there was just this juxtaposition between PO and Atiku's petition, because there was a similar ground. But he's going to give a breakdown for the Atiku zone before we can now start chipping in. But instead of just closing up PO, anything someone wanted to add on the PO's petition can be imputed now. That was what we're actually trying to do. So is that a go ahead? Okay, so for me, I was just thinking the second ground was just on the non-compliance, and that's what I was saying. For PO, he actually subsumed his non-compliance and the corrupt practices into one. And then for the Atiku's petition, Atiku actually demarcated the non-compliances and the corrupt practices into different grounds. And so that makes it we're actually talking about the issue of corrupt practices. We're still talking about the issue of non-compliance, but I was majorly trying to just say, okay, what's different between this and what's different between that? And there's almost similarity. For PO, he's saying that section 135 of the Electoral Act was not actually followed through, based on guidelines of 11th of November, whereby INEC insisted that the reason for introduction of IREV was to ensure the integrity. So without for you introducing a mechanism to ensure the integrity and credibility of an election, you not doing so automatically tells us you're not complying with your guidelines, you're not also complying with your laws. And the laws already captures whereby the electoral body has to actually follow the necessary process. And for anyone that actually wants to look through it, can actually check section 47, section 60, section 60 sub 5, section 64, all this of the Electoral Act. In all of it, some part of it were not followed through. So when it comes to transmitting of the results, so this was what I was trying to talk about. The particular issues that failed to follow the non-compliance grounds, those were just what PO's petition was just trying to talk about. So, and then also talked about that they have 18,000 polling unit results that were not actually corroborating what was actually uploaded. So blood results were not actually put into those uploaded on the IREVs. So those are part of the issues they are going to actually be focusing on. That it was intentionally done. That is their claim. They are alleging that the electoral body intentionally uploaded blood results. So to the extent that they have these results, they're actually going to be tendering it into evidence to show that these results were actually not clear enough for people to actually know, and then also believe in the integrity and credibility of INEC. And then also talking about why they also have limited resources, unlike what it should have been, was that they had asked the court the right for them to request and inspect and obtain the relevant documents, and it's the right of any candidate or even a person, according to Section 74 of the Electoral Act, you can actually ask for documents from INEC. But yes, going a step further, they actually got and obtained order from the court, which actually limited them to have handy documents for inspection, and also for them to be able to extract some of those results that INEC had collected from the point of voting to the point of upload, and at the end of the day. So that's why they have limited. Because I heard when UC Maxwell was talking about the issue of Rivers, Benue, and Bayelsa, it was just to this extent they have the documents which they obtained, and they rightly said 4 out of 8 Bayelsa's documents were given to them, few out of which they kept on writing letters upon letters. 4 letters given to INEC was still all to no avail. So I think these are just some of the things I wanted to add as we proceeded with the next petition. Thank you.
Thank you, Barrister Juliet. Sorry once again. Okay, guys, let's hear from Barrister Doja, the Atiku's petition in summary. Barrister Doja, go for it, sir.
Okay, thank you very much. So I think before I proceed with the breakdown of Atiku's petition, I think it's important to note that Peter Obi's petition, essentially, as simple as it looks on the surface, is a petition loaded with landmines, meaning that once they start to go into the substance of that petition, if you are able to avoid first ground, you'll be at the second ground, you might get caught up in it or get caught up in the third ground. So it's a petition that is loaded with landmines, very well put together, and very simple, but goes straight for the jugular. So it's a very dangerous petition, let me put it that way, especially with the dimensions it is introduced. Now, moving into Atiku's petition, I think before I commence the breakdown, it's important to appreciate Atiku's contribution to Nigeria's jurisprudence. You see, Atiku as a candidate is one that has always believed in the courts, and for every single time he's gone to the courts, he's always contributed positively to Nigeria's jurisprudence. And maybe because he's a veteran in the game and, he's been contesting elections for a long time, he's probably figured out what works, what does not work. And as a former vice president as well, he's an establishment man. So his petition is very verbose. It's loaded, very heavy. And, the thing with Atiku's petition is that in contrast with Peter Obi's petition, Atiku's petition goes into more details. And the details it goes into are quite graphic of essentially what happened. I mean, the picture of what happened before, during, and after the election. And while Peter Obi's petition puts the judiciary on trial, because essentially it's putting the judiciary under international spotlight and then bringing constitutional provisions which the judiciary they have to pronounce on, under all that level of scrutiny. Atiku's petition puts the Independent National Electoral Commission, which we all know as INEC, on trial. His petition has 4 grounds, and the 4 grounds of his petition are that the election of Tinubu is invalid by reason of non-compliance with the provisions of the Electoral Act 2022, that the election of Tinubu is invalid by reason of corrupt practices, that Tinubu was not duly elected by majority of lawful votes cast at the election, and that Tinubu, the last ground is that Tinubu at the time of the election was not qualified to contest the election. Now, that last ground, whether it's Tinubu or Shettima, we'll get into that, but pretty much he's saying that their ticket was not a ticket that was qualified to, contest the election. So, it started with the fact that when it came to the elections, the electronic transmission of votes in the elections, that INEC did not comply with that, and went into details as to how in different places it has witness statement of votes from pretty much all the states in Nigeria, which evidence the fact that while electronic transmission was happening for the National Assembly positions, for the presidential election, no electronic transmission happened. But you see, that's why I said Atiku's election petition is very rich and verbose. You see, The finest point I picked, I'm going to go into the other three grounds, but the best point of Atiku's petition I picked is that, you see, Atiku does not stop at the fact that the INEC promised to transmit and did not transmit. Atiku actually goes into details to tell us why INEC did not transmit and what really happened. So, by going into details, he went as far back as going into INEC's procurement process and shedding light on the fact that Senator Aisha Binani, the now the gubernatorial candidate for the APC in Adamawa, who is supposed to participate in a supplementary election because Adamawa has been declared inconclusive, that she was the printer for the ballot papers in Nigeria, and that INEC was aware that she sat on the board of the printing company, and that despite the fact they were aware their internal controls is a red flag, and that by so doing, they put APC in a position to know everything there is to know about the ballot papers and the process, internal process with respect to the ballot papers for INEC. Now, with respect to the IRF technology, he went as far as identifying the fact that the company that supplied the Beavers machines, it's called Activate Technologies, is owned by Senator Sani, a current sitting senator of the APC from Niger State. Then he went as far as tracing that the fact that the Beavers machines, where they were supplied from, and that by giving that contract to Senator Sani, they wanted to the APC to be in the know and understand how the Beavers operates. Then he traced it back to the INEC official that was removed, who used to be in charge of the IT, that's the Beavers infrastructure, who was then redeployed. I think they said was redeployed to Enugu as an administrative secretary. So that the INEC official, after he was redeployed, a certain consultant was brought in, and that he mentioned the name of the consultant. I think it was Suleiman something. I'm sorry, the names are not coming to mind now. But a consultant was brought in, and that unlike in the previous two elections in Oshu and Ekiti, whereby when you upload to the Beavers, immediately the Beavers you upload to the Beavers, immediately documents are uploaded to the Beavers, it sends it directly to the HiRef portal and then displays it for everyone to see. That in this particular electoral cycle, that because INEC had been planning and it was premeditated that they had been planning with the APC to hand the election to the APC, INEC brought in that consultant, and the consultant deployed a third-party application to stand between the Beavers and the IRF technology. So the third-party application then filters whatever is uploaded from the Beavers to the IRF, which explains how the APC is able to alter and change results or send in results that are not what was initially uploaded from the Beavers. So he is saying his petition is alleging essentially that this was collusion and that this collusion was premeditated, and that person, that third party application, probably would have been in a position, to switch off the IRF portal essentially. And then he goes more into details on the security apparatus of the IRF portal and the Beavers, saying that it was secured by Kapasky. Kapasky is an international company, by the way, in South Africa, and the security audit was conducted. And when it was conducted, it was like 99.99, which shows that the IRF portal or the Beavers could not have been hacked from outside, based on the result of that security audit. Then went as far as saying it was hosted on Amazon AWS, and that it being hosted on Amazon, there were two, like the main one and the backup, and that should the main server ever go down, the process of moving the information and all to a backup is seamless, and that has a 99.999%, you understand, 99.999 success rate percent, and then like 0.0001 percentage of failure. And so he's also subpoenaing someone from the Kapasky company. He's subpoenaing from AWS as well to testify. So he's also subpoenaing, the official from the company that actually participated in security audit procedure for INEC. He's also subpoenaing the consultants who INEC, brought in to act as a filter. Then he claims that the consultant deployed his staff there to manage the Beavers inside INEC. He didn't mention who the staff was, but he's essentially saying that, see, the election that was conducted was not between myself, Labour Party, and NMPP and APC. This was between the rest of us versus APC and INEC. And that INEC was an active participant in that election because it was premeditated. The fact that INEC, the Beavers had worked successfully. If it was working successfully, why do you need to introduce a third-party application that will filter whatever is uploaded and subject that process to manipulation? And that they're claiming they were attacks, but based off what they have, it shows that it was an internal, somebody switched it off from inside and then went on to justify the fact that to bring out the fact that INEC appointed a consultant, and that consultant appointed by INEC was probably wasn't necessary, was done with the sole intention of rigging the outcome of the election in favor of the APC. So, with respect to that, we have to give it to Atiku's team. Those are information that is privileged, and is only his status as an establishment man, that would have given him access to such level of information, especially with respect to INEC's procurement process, the faces behind it, and the consultants and all that. So, in alleging corrupt practices, you understand, this is part of, and for under his first ground, this comes into play, and also under the corrupt practices that INEC was corrupt. Then he also mentioned the fact that INEC did not go along with the regulations, that they had created, which is with respect to the transmission of results. That was pretty obvious. That's also very similar to what was put in Peter Obi's own petition. Then the second strongest part, for Atiku's petition, I think this has to do with the fact that the APC did not get a majority of the lawful votes cast. And, he went into details. And the detail he went into essentially is that during the election, the violence broke out, in different areas, different states in the country. And according to Atiku's petition, there's over 18,000 polling units that were cancelled as a result of violence. And that the total number of polling units, that were cancelled, when you calculate the number of votes, that's the number of PVCs that were collected. The number of PVCs collected is more than the winning margin between himself and Tinubu. So he's saying that the margin between his votes and Tinubu's votes, compared with the number of voters who were disenfranchised, it's more. And according to the Electoral Act 2022, as amended, when that happens, there are supposed to be supplementary elections held across board in all those states that were affected and the polling units. So he went, with a statistician, he listed all the polling units that were affected in his statistician's report, which he pleaded as part of his evidence. Then, that's for me is very significant, because that has happened in Osun State. That was the previous election before this one, in which Mr. Adeleke won. And that was on the basis of that also that, in Adamawa, that INEC essentially declared Adamawa inconclusive. So he went further, because there was the benefit of hindsight in the gubernatorial elections to say that INEC cannot be selective with applying their rules and applying, the Electoral Act. That's what the Electoral Act states. So essentially, they are supposed to do runs in those constituencies. Then he also went deeper to identify areas. He identified a state actually where BVAS was not used, and says that because BVAS was not used, he doesn't believe the results of that state, should be admissible. Then he went further, to identify areas where overvoting occurred. And when overvoting occurs, what he states is that the results from those areas should be cancelled. So he went further to identify the places that overvoting occurred. This also had to do with the grounds, one of the grounds that he pleaded as well. I'm trying to identify the exact ground. So then, in addition to that, he mentioned the deliberate suppression and discounting of lawful votes. So he says that even after the election had occurred, and then the results came out, the APC then manipulated the results, put in the IRF portal by taking out of their own votes and adding to the APC's votes, and then after taking from his own votes, adding to the APC's votes, and then putting it on the portal and putting that as the final result. So he went into details, you understand, on that. And then, in addition, there's this thing that INEC is supposed to do. It's one of his INEC's internal process, and is in accordance with INEC's manual, that when you go for an election, by the time they're done with that election, I mean, from the polling unit, I believe that you're supposed there's a document where you are supposed to write it down, the number of unused ballot papers, number of used ballot papers. It's like an accounting thing, really, to take account and more like take stock, so that the results of that place will not be subject to manipulation. According to him, he says in about 20% of the total results that were put forward by INEC did not comply with that particular regulation. And then he also pointed out the discrepancies, from the high-rev as well, and give a percentage to it, that the results that we're seeing on the high-rev, he mentioned the inconsistencies, with respect to that. And he didn't just mention them, he went into details to list all the polling units, that were affected. That's in the different local governments. That's from Sokoto to Kogi, all the way down to the Lagos. He listed all the different polling units, and exactly how they were affected. Then, in addition to that, when he said that they did not get majority. They were not duly elected by majority of lawful votes cast. Now, by majority of lawful vote cast, he pulled in that Federal Capital Territory, the Federal Capital Territory 25% one, where he says that they didn't score 25% in the FCT, and that by not scoring 25% in the FCT, they've not fulfilled the conditions of that the Constitution stipulates, essentially, before they can be declared winner. And in addition to that, it says that the results, from 19,702 polling units contain various forms of infractions, and that a total of 4,307 polling units are without stamp on the respective Form EC8A. And in addition to that, it says 1,300 polling units do not have signatures of the presiding officers on the respective Forms EC8A. And then results from 6,418 polling units have and indicate zero accreditation. Now, it's very important to know that from INEC, the Electoral Act, and if there's no accreditation, it's almost like there can't be an election. You understand? So he also mentioned that critically, 9,463 polling units across 30 states have shown that votes returned are in excess of accredited voters. That's overvoting. So that's why, like I mentioned earlier, I said Atiku's election petition is very, very detailed. Like, what I mean by detailed is as detailed as, he mentioned where the governor of Kogi State, Yaya Bello, was, he stopped, the elections could not be conducted in areas in Kogi State because he had cut off the roads. And he mentioned the polling units that were affected. Then he went all the way to Imo to mention areas where elections did not occur and results were uploaded. Then, in addition, to that, he also mentioned in Lagos State, where 20 local government areas where there was violence, mayhem in a manner never seen before in the history of Lagos State, and there were indiscriminate shooting of guns, physical attacks, and that all the votes, that's basically the votes in Lagos State were manipulated, and that they are based on the manipulation, they are liable to be voided. That's the votes from Lagos State. Then, in addition to that, I think one of the areas where Atiku's petition, really stands out, like I said, is the details. The details of Atiku's petition are very graphic. Like, he really, really went into details of the election. So okay, just a minute, sorry. I just want to confirm that I've covered all the grounds. I've covered corrupt practices and covered lawful votes cast. Oh, yeah. The last one I haven't covered is the second respondent, that's the APC at the time of the election was not qualified to contest the election. Now, what Atiku means by this, he didn't state, but I believe that he intends to, pull a shocker, he intends to pull out a joker on that one. And when I mean a joker, we all know that, first of all, Tinubu has had issues with his certificate, which David mentioned. For some reason, which I do not know, Peter Obi and his team did not focus on that. That's on the qualification with respect to certificates. But Atiku, maybe if they know Atiku is focusing on that, maybe Atiku has better information on that, I do not know, but I believe that might be one of those things. But he mentioned it there. That means is in the course of the case. They are going to be unveiling why they think they are not qualified. The double nomination thing as well can come to play. And Atiku's prayers, at the end of the day, is that he be declared the president if all the votes that were taken and the polling units, it's either that after the subtractions and additions are done, he be declared the president, or a rerun election be declared between runoff election should be conducted between himself and Bola Ahmed Tinubu. That's across the entire country.